You know that moment, right? You're faced with a contract, and there it is, that giant wall of tiny text that we all just scroll past. But what's actually hiding in that fine print? Well, today we're going to pull back the curtain on one of the trickiest parts, something called an exclusion clause.
So picture this. You've bought a service, something breaks or goes completely wrong, and when you complain, the company just points to some little line in the fine print and says, "Sorry, not our problem." It feels totally wrong, right? But the big question is, can they actually do that? Is that legal?
Well, that sneaky bit of fine print has a name. It's called an exclusion clause. And its entire job is to limit or completely get rid of a company's responsibility if something goes sideways. It's basically them saying, hey, if this happens, we're not liable. But, and this is a huge but, just because they wrote it down doesn't automatically make it ironclad.
Okay, and this is probably the most important thing you'll hear today. For that fine print to actually hold up in court, it can't just be there. It has to pass a really important three-part test. And get this, if it fails even one part of that test, the whole clause can be considered completely invalid.
All right, so let's dive into test number 1. It's all about something called notice. And the question the law asks is super simple. Was it obvious? I mean, did they actually give you a fair chance to see this clause before you agreed to anything? They can't just bury it and hope you don't notice.
And you can see the difference pretty clearly, right? On one hand, you have sufficient notice. The clause is right there. Maybe it's even in bold on the thing you're signing. But on the other hand, insufficient notice. We're talking about text so tiny you need a microscope, or a link hidden on some obscure corner of their website. The point is, they have to make a reasonable effort to show it to you.
And that's really the heart of it. If you can look at it and say, come on, the link to the terms was buried at the bottom of the page, I never even saw it, then chances are they've failed this first test. It's all about fairness. It has to be visible.
Okay, so on to test number 2. Let's say you did see the clause. The next question is, could you actually understand what it meant? This is all about clarity, or what lawyers call the principle of ambiguity. The language can't be a bunch of confusing gobbledygook.
And this is a perfect example. Something like, we are not responsible for accidental damage. Okay, that's pretty clear. We all get that. But what about, liability is hereby excluded for all resultant contingent eventualities? I mean, what? That's just a mess of legal jargon. And here's a fun fact. If a clause is that vague, courts will often rule against the company who wrote it.
Exactly. I mean, I'm not a lawyer. How was I supposed to know what contingent eventualities even meant? At its core, a contract is an agreement. Both sides have to know what they're agreeing to. Trying to trip people up with confusing language is a massive red flag. And yeah, it can absolutely get that clause thrown out.
All right, which brings us to the third and final hurdle, the principle of scope. This one's all about context. Basically, the clause has to actually fit the problem that occurred. It can't just be some vague catch-all excuse they can use for anything. So, think about it like this. Let's say a contract has a clause for wear and tear. If your new table gets a little scuff mark, okay, that's probably within scope. But what if they try to use that same wear and tear clause to cover the whole thing just completely falling apart? No way. That's a huge stretch. It's totally outside the scope.
Yeah, exactly. You can just hear someone saying, the contract excluded liability for minor cosmetic damage, not the engine completely failing on day 1. The clause has to match the crisis. You can't use a Band-Aid excuse for a major disaster.
So let's wrap this up into a simple checklist you can actually use. First, notice. Was it brought to your attention? Second, clarity. Was the language crystal clear? And third, scope. Does it actually cover this specific problem? Notice, clarity, scope.
And here is the absolute key. It's not a best 2 out of 3 situation. To be valid, that clause has to pass all 3 tests. No exceptions. It has to be obvious, it has to be clear, and it has to fit the situation. All 3.
So, why does all this matter? Because knowing this stuff isn't just some interesting legal trivia. It's a tool. It's your power. It helps you cut through all that confusing jargon so you know exactly where you stand. Think of it as your personal 3-point checklist.
So, the next time you're in a situation where someone points to the fine print, you can just quietly ask yourself these questions. 1. Did I have a fair chance to even see this thing? 2. Could I actually understand what it was saying? And 3. Does it really apply to what happened here? Just asking those questions gives you the confidence to push back. So I'll leave you with this one final thought. We click that little I agree box probably multiple times a day without even thinking about it. But now that you know about notice, clarity, and scope, the next time you see that box, What are you going to question? What's really hiding in that fine print?